The state has requested that I find additional aggravation. The court does find that in CR 2021-001704, the offense was committed in the expectation that you would receive pecuniary gain. In the CR 2022-001242 case, the court finds the emotional harm suffered by Brandon and his family to be immeasurable. The sentences on those aggravating factors alone will be justified. The state also asked to find an aggravating factor of a prior felony conviction within 10 years of this offense. However, I'm hesitant to do that just because of the way that statute reads, that the offense had to be committed before the date of the offense on these two crimes, which it wasn't. So the court will decline to find that aggravating factor. However, as I said, the substantial amount of harm to the victims and the victim's family, emotional, financial, and otherwise, are immeasurable and justifies consecutive sentences. Ms. Vallow, what's your position on Ms. Woodcock's restitution request of $8,949.52?
I just received it from my advisory council, and I'd like to get a chance to look at it. So I know that the restitution from Brandon hasn't been turned in yet, so we'll look at that, and I can discuss it with my advisory council.
Would you want to waive your appearance for a restitution hearing in the future and have your counsel handle that?
I don't see why I couldn't appear by Zoom.
I think my request would be just to leave, not waive her appearance at this time, but if there ends up being some restitution hearing, I can reach out to her and decide if she wants to be here for that.
I'm not going to have her extradited from Idaho for a restitution hearing if she wants to appear, so that's my issue here. She may be able to appear virtually, I don't know.
Because at this time, we don't have the restitution from Mr. Boudreaux, so.
All right. I'm going to set a status conference regarding restitution as to Kay Woodcock. We'll set that in a few moments. If you agree to it prior to that date, we'll vacate it. If not, we'll have to talk about setting a restitution hearing. The court will also, at the request of Brandon Boudreaux, issue a lifetime injunction that prevents you from having any form of contact whatsoever with him for the rest of your life. The court will also issue an injunction on behalf of Susan Vallow, Kay Woodcock, and Jerry Vallow that likewise prohibits you from having any form of contact with them for the rest of your life. You'll be served with those injunctions later today. In each case, it's ordered that you pay a $9 victim compensation fund assessment, a $20 probation assessment, a $2 victims' rights enforcement assessment, and a $13 criminal penalty assessment. Although it's largely symbolic, the court's going to impose the maximum fine allowable for each case. It's ordered that you pay a $150,000 fine plus a 78% surcharge on each case. Those total fines on each case is $267,000. I know the law says that you can't financially benefit off your crimes, but in the event that somehow you did, those restitution amounts or those fine amounts are out there that can be paid. As to count 1 in CR 2021-001704, the court orders you to be sentenced to life in prison with the possibility of parole after serving 25 calendar years. This sentence would run consecutively to the District Court of the 7th Judicial District of the State of Idaho in Fremont County, case number CR 22-21-1624. As to count 1 in CR 2022-001-242-001, it's ordered that you be sentenced to life in prison with the possibility of parole after serving 25 calendar years. That sentence also, due to the number of victims you've created in the two cases, the immeasurable harm you've inflicted on many, it's ordered that that run consecutive to CR 2021-001-704. Because these sentences are consecutive to one another and consecutive to the Idaho case in which you are currently serving a sentence, you're giving 0 days credit for time served. You have the right to appeal from the orders of the court and to have a lawyer represent you. If you cannot afford a lawyer, one will be appointed for you. If instead you want to represent yourself in your appeal, you must file a written waiver no later than 30 days after the filing of your notice of appeal. If you cannot afford copies of the necessary records and transcripts, they would be provided for you at no cost. If you want to appeal, you must file a notice of appeal within 20 days of today, or you lose that right. If you want to petition for post-conviction of relief, you must file a notice within 90 days from today, or within 30 days after the appellate court issues a mandate affirming the judgment and sentence in your direct appeal, whichever is later, or you would lose that right as well. It's ordered remanding you to the Custody Department of Corrections effective today to carry out those sentences. We're at recess.
All right. Lori, right in prison. We can't do that. Let's go. Everyone out now.